Hello, 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 hello. Oh, um, thank you all for joining this webinar today. This is an OxFirst webinar. It is being recorded. Um, Starting off with a disclaimer, the views, opinions, presentations expressed are those of the speakers. They're not those of OxFirst, myself, etc. I also think these are the personal views of the speakers and also not necessarily those of the institutions they work with. In a word, these are views, but nobody really is responsible for these views. We're really extremely delighted today to present such a great panel to discuss the Japanese guidelines on FRAND and FRAND royalty rate determination. I think Japan has made an important contribution here by starting to consider ways or governance structure of how to organize FRAND. And I was really, really happy to see that Yoshihashi Kodachi from the Japanese Patent Office agreed to present the work of the Japanese government. And he asked me to make it clear that he is speaking on behalf of the Japanese Patent Office, not necessarily on behalf of the Ministry of Economy, Trade and Industry, the METI, because there are slightly differences of views within Japan on the topic still. We also have, so Yoshiaki is currently based in Düsseldorf. He's here as a Japanese representative to Europe, I would say, working also on trade relations between Europe and Japan. And he's a patent examiner by background and so he knows his stuff. And he can say something also on substantive IP. Professor McDonough holds a professorship now at the London School of Economics since very recently only. He went back to London to the LSE after having worked for years at City University, and he focuses on IP and constitutional law. Professor Bonadio is still with City University, where he is equally focusing on intellectual property law and has also another, among others, interest in FRAND. And I invited them because I thought that they had been writing and started to think about the topic, and it could be interesting to have academic commentators also add to the position. OxFirst, by background, for those who do not know us, is a spin-out from Oxford University. We have been up now for 10 years. Our aim is to promote an IP economy for all, I would say, and to leverage wealth and prosperity on the basis of intellectual property in both developed and developing countries, and to offer an equitable society. We have a strong passion for economic aspects of IP and IP law and society in general. So we work on IP valuations, on damage assessments, damage calculations, licensing rate determination, economic impact assessments, IPR policies, and have been quite involved in FRAND the last couple of years. And we also run a big conference in Brussels on FRAND, where many of you have attended, and I very much keep my fingers crossed we can run it again next year. With that being said, I now pass on the floor to Yoshiaki, and I'll bring your PowerPoint up on my screen so people can, and you just tell me maybe when I should change the slides. Wait, where are we? Here we go. 1 second. This is always the stress. Share screen. Where are you? Here you go. Share. Is it good? Yes. Yes. Okay, Yoshiaki, the floor is yours.
Thank you, Roya. Good afternoon. My name is Kodachi Yoshiaki. First of all, I would like to thank OxFirst and especially Dr. Roya Gafferi for giving me an opportunity to speak about recent developments on FRAND and SEP in Japan. Today, I will talk mainly about the guide to fair value calculation of standard essential patent for multi-component products published by the MITI, the Ministry of Economy, Trade and Industry, in April of this year. Before explaining this guide, I'll cover its background and another guide published by the JPO, the Japan Patent Office, in 2018, because the JPO guide is treated as a basis of the MITI guide. Next slide, please. This diagram shows illustration about wider scope of application of SCPs. As you can see in the right-hand side of this diagram, in the past, negotiations mainly took place among mobile device manufacturers. More players from a wide range of industries become involved in SCP negotiation. For example, as you can see in the left-hand side of this diagram, many players in supply chain of a car manufacturing industry, such as car company and various level of suppliers, can be involved in license negotiation. Next slide, please. This slide shows situation changes of SCP licensing negotiation. In the past, negotiation counterparty of ICT company was also ICT company. Therefore, cross-licensing agreement was one of the practical options. It was relatively easier to forecast licensing rates and evaluate essentiality of the relevant patents among parties. However, with spread of Internet of Things, the parties in SCP licensing are becoming diversified, and the negotiations are often performed among parties from different industries. This structural change of the parties makes it difficult to solve problems by conventional cross-licensing approach. And it also causes discrepancies among parties in perspectives on license rate or essentiality of the patent at issue. Next slide, please. This diagram shows major lawsuits and administrative actions concerning SCPs. As expanding the scope of the application of SCP technologies, relevant disputes are arising from different business all over the world. Next slide, please. To find solutions to overcome these difficulties in SCP negotiations and disputes, the JPO thinks that three factors should be considered. First, balancing between SCP holders and implementers. Second, resolving global disputes in a swift manner. And third, increasing predictability and stability for parties involved in negotiations and disputes. Through the analysis based on these criteria, the JPO found it important to provide useful information about the SCP licensing negotiations because it is often not easy for parties who are unfamiliar with standards to understand what is necessary for good licensing negotiations. The JPO thought that if it could provide appropriate information, it would enable both parties to negotiate with a common ground and would help them prevent or quickly resolve the disputes. To provide correct information to parties who are not familiar with SCPs in order for smooth licensing negotiations and rapid dispute resolution, the JPO took two initiatives. The one is making the guide to licensing negotiation involving standard essential patents, and the other one is introducing a new system for essentiality check. The first initiative is related to today's main topic. As you can see in the blue box, this guide summarizes issues concerning licensing negotiations as objectively as possible. Next slide, please. This slide shows overview of the JPO's guide. In accordance with our intention of making this guide, the JPO made it clear the purpose of this guide in Chapter 1. It clearly states that this guide is neither legally binding nor intended to be prescriptive. In Chapters 2 and 3, this guide identified points that each party should note when performing the license negotiations for SEPs in terms of license negotiation methods and royalty calculation methods, respectively. It is written both in Japanese and in English, and they are available from the JPO's website. I'll explain some important points with the following several slides. Next slide, please. This slide is about licensing negotiations in good faith. Although it is not directly connected with royalty calculation, it is one of the important aspects on license negotiations. The 2015 decision by the Court of Justice of the European Union in the case between Huawei and ZTE provided a framework for good faith negotiations between right holders and implementers by identifying action which each of the parties should take at each stage of the license negotiations. The JPO guide says that the framework is considered to be a useful approach to encourage good faith negotiations whereby right holders may fulfill their FRAND obligations and implementers may minimize their risk of an injunction regardless of the differences among jurisdictions in the legal basis for stipulating negotiation rules for FRAND encumbered SEPs. I think that the careful monitoring in this area is necessary because the situation is rapidly changing after publishing the JPO's guide. Next slide, please. This slide explains about non-discriminatory licensing. Although FRAND licensing terms have to be non-discriminatory, this does not mean that all potential licensees must obtain licenses at the same royalty rate and amount. It is instead considered to mean that the similarly situated licensees should not be treated differently. Factors in considering whether licensees are similarly situated include whether the standard technology is used in the same way, the level of the company in the supply chain, and the geographic scope of the licensee's business activities. In an IoT era, ICT is being used in various industries, and some right holders consequently argue for different royalty rates and amounts for the same standard technology according to the particular use of that technology in the end product. On the other hand, some implementers argue that the same royalty rate and amount should be applied for the same standard technology regardless of the means by or extent to which it is used. Here, conflict of opinion between right holder side and implementer side is seen. Next slide, please. This slide is about parties to negotiate in supply chain. As you can see, a diagram in the left-hand side of this slide, this is an issue as to who SEP holder negotiate with in supply chain. There may not be a problem in selecting the parties to negotiations as long as the parties can agree based on industrial practices. Problem may arise, however, if, for example, a component installed in the end product uses SAP. In general, the right holder is in the position to decide with which party in supply chain signs an agreement. For example, end product manufacturer, component manufacturer, or subcomponent manufacturer. Meanwhile, there is some debate globally on whether FRAND encumbered SEPs should be licensed to anyone who desires to obtain such a license. License to all is the idea that right holders must license all entities wishing to obtain licenses regardless of the level in the supply chain. On the other hand, there is an idea that the FRAND declaration is not a requirement for licensing to all parties using standard technology, but is rather a mechanism to ensure that those who want to use standard technology can access that technology. It is called as access for all. As you can see in the right-hand side of this slide, SEP holders argue that it is inappropriate that end product manufacturers refuse to negotiate when the right holder asks the manufacturers to be a counterparty of license negotiation. End product manufacturers insist that it is discriminatory and a breach of FRAND obligation that SEP holders refuse negotiation with suppliers of subcomponents as counterparties if the end product manufacturers request SEP holders to do so. Next slide, please. In order to determine appropriate royalty rate, two approaches are frequently seen in court decisions. One is determining the share of contribution of a particular SEP by referencing, for example, existing comparable licenses called bottom-up approach. And the other is calculating the share in the calculation base of the contribution of all SEPs for a given standard and then allotting a share to individual SEPs, so-called top-down approach. These two approaches are not contradictory. Both approaches may be combined to calculate the rate so as to ensure a more reliable rate through comparison of the results. When many right holders individually demand royalties, there may be cases in which each royalty stacks up, making the cost for practicing the standard excessively high. This is called royalty stacking and is an issue that may occur when there are many right holders that hold SEPs for the same standard. As the extent of the contribution of all SEPs to the standard defines the total rate, there is a view that the top-down approach is effective in avoiding such royalty stacking. Next slide, please. This slide is about the basis for calculating royalties. In the days when debate focused on cellular phones, where communication technology was central to functionality, many parties supported the use of the entire market value. However, in the case of products such as smartphones and self-driving cars, communication technology accounts only for a part of the product's functions. It raises debate over the use of the smallest sellable patent practicing unit or the entire market value. For example, some argue that when the essential part of the SEP technology supports the operation of functions of a device larger than a chip and contributes to the functions of the device beyond the chip itself, using the price of the chip as the SSPPU may not reflect the real value provided by the SEP technology. On the other hand, others suggest that when the contribution of essential part of the SEP technology is confined to the chip itself and the chip is independent and has an objective market value, the price of the chip may be deemed appropriate as a calculation base. Contrarily, there is an approach using the EMV as a starting point of discussion and determining the calculation base by multiplying the end product by the ratio of the contribution to the end product of all SEPs that cover the technical standard. SEP holders insist that EMV should be used if the SEP technologies contribute to a function of entire end product and they increase demand for products. Implementers argue that SSPPU should be a basis of calculation of royalty if the SEP technology is used only to subcomponent as SSPPU. Here also we can see conflict of opinions. Next slide, please. So let me talk about the guide to fair value calculation of SEPs published on 21st of April 2020. This guide was published by the METI. For your information, the JPO is also under the ministry, but this guide was made independently from the JPO, as kindly Roya explained. As I explained earlier, the JPO guide describes various standing points, including both implementer side and right holder side, about treatment of royalty calculation and parties to negotiate as objectively as possible. On the other hand, METI's guide indicates specific positions on several aspects. The new guide is based on the report of a study group of the research project commissioned by the Manufacturing Industries Bureau of the METI. The Bureau is promoting digitization of manufacturing industry, such as Internet of Things. In this context, the study group was set up from concern that SEP disputes would prevent advancement of the industry. The background of the METI guide is almost common to the JPO guide. In addition, it was also of the METI's view that this guide could facilitate SEP licensing negotiations by showing certain aspects, and it could avoid risks of prolonged negotiations that would potentially be obstacles for promoting Internet of Things. The guide is non-legally binding, and as I said, it shows certain aspects only as reference. The METI's guide sets out 3 principles for fair value calculation of SEPs. I'll explain details later. In addition, it alerts small and medium-sized enterprises that are facing to SAP negotiations and disputes. As IoT spreads into the economy and the society, it is expected that the number of cases where SMEs use IoT will also increase. And in the future, negotiations and disputes between right holders and SMEs on SAP licenses are easily expected to increase as well. However, in general, compared to SAP holders and large companies, SMEs are at a greater insufficient resources for dealing with SAPs, such as professionals and information on negotiations. So it is the METI's concern that such SMEs risk could be increasing if IoT technologies becomes widespread without having the awareness and information on IP. Therefore, the METI guide encouraged that when an SME receives the demand for concluding a license agreement from a SAP holder by warning letter, it should firstly consult with an intellectual property expert and consider appropriate measures. The guide also recommends SMEs to use the JPO guide as well as reference. Next slide, please. So I'll explain each principle briefly. First principle is that the parties to a licensing agreement should be decided based on the concept of license to all. This is because SAPs are literally required to be non-discriminatory as a FRAND condition. They should not treat the potential implementers discriminatorily based on their transaction stages. Another reason is that in the case of multi-component product, an entity possessing detailed knowledge of the main product that implements the SAP technology exists somewhere in the supply chain. Appropriate royalty can only be calculated by the entity with such detailed knowledge. Therefore, the party to the negotiation should not be limited to the end product manufacturer in order to calculate the royalty appropriately. In the study group report, the 2019 District Court decision on FTC versus Qualcomm case in US and Nokia versus Daimler cases in Germany, and so on, are taken as relevant court cases. The study group report also says that there was an opinion that it is possible for an SAP holder to pursue a contract that end product manufacturer has to pay license fee in a lump sum. So the SAP holder cannot refuse license offer by supplier. The guide also adds that in the case based on the license to all concept, The SEP holder may claim royalty from, for example, both the supplier and the end product manufacturer with regard to the same SEP technology implemented in the multi-component product. In this case, the SEP holder should avoid the double gain of royalty from multi-sub-entities in the supply chain. Next slide, please. Second principle is that royalty should be calculated using a top-down approach. Top-down approach determines the appropriate rate by calculating the ratio of contribution by all SEPs to the standard. Therefore, it can avoid the royalty stacking problem, and also it is appropriate as it enables also all SEP holders to obtain a fair share. The study group report cited Innovatio IP Ventures versus Cisco Systems et al. Case in 2013 US District Court decision and Japanese IP High Court decision on Apple versus Samsung case in 2014 as examples of top-down approach. The study group report said that there was an opinion that a risk of royalty stacking could not be ignored. However, it was also pointed out that the use of bottom-up approach together with top-down approach should not be denied for the purpose of cross-checking reasonability of calculation. If there are sufficient grounds of royalty calculation of each standard essential patent. Next slide, please. Third principle is that royalty should be calculated based on the portion to which the SAP technology contributes, that is, contribution rate, in the value of the main product that implements SAP technology. There is controversy over whether to adopt SSPPU or EMV for the calculation of royalties, but this principle comes from a thought that the choice of the basis of royalty calculation between SSPPU and EMV is not so important. However, if the party do not consider the calculation based on the strict contribution rate to be practical, a simpler calculation method may be adopted, such as setting the royalty per product to a fixed amount. Even in that case, it is basically desirable that the fixed amount does not greatly deviate from the amount calculated based on the contribution rate. In this regard, there was study group members' opinion that characteristics of a product needs to be taken into consideration when it comes to calculating fair value based on the degree of contribution to demand stimulation for the product. Furthermore, it was pointed out that it is not logical to treat the price of a whole car as a basis of SAP royalty calculation, and it is important to consider contribution rate of SAP technology. Because, for example, connected car works as a car itself, even if its connected service is not available. Also, it is usual that the price of service realized by the technology is separated as an optional feature from the price of the vehicle. Next slide, please. So I'll talk about how the current discussion about IP policy, in particular on SAP matters at the JPO. For this, I briefly explain about Patent System Subcommittee. The subcommittee is set under the Intellectual Property Committee, which is one of the advisory bodies of METI and stipulated by the government ordinance. In general, when the important policy decision on patent system, including law amendment, is made, the subcommittee discusses and reports for the government. The subcommittee consists of judges, academics, lawyers, patent attorneys, and representatives from private sectors, and the JPO is secretariat of the subcommittee. Since September 2019, the current discussion round has been held, and the subcommittee has deliberated future patent systems suitable for the AI and IoT era. As one of the items to be considered, FRAND negotiation between parties from different business is listed. And just for your information, other listed elements at the discussion round are, for example, separation between a court decision on infringement and a decision on damage compensation. Limitation to disclosure of evidence to the party himself, like attorney's eyes only. And introduction of call for submission of third parties observation by court, like amicus curiae in US. And, improvement of damage compensation and revision on injunctive relief and so on. These items are currently under consideration, and each item will not necessarily be implemented. Next slide, please. Interim report of this discussion at the subcommittee was published in July 2020. The report is written only in English, in Japanese, but I will try to explain outline of the SAP FRAND part of it. Please note that these contents are not official translation, but just reference. Firstly, the METI guide is mentioned in this interim report, together with other factors in the FRAND negotiation. This report refers some opinions of members of the subcommittee to the METI guide. One of them appreciated the fact that the government expressed its specific position in several aspects on royalty calculation. On the other hand, it is pointed out that the METI guide is still on the presumption that tangible goods-based industry, while the industry structure is rapidly changing to service-based intangible consumption. Therefore, it was also pointed out that the further discussion is necessary, taking such structural changes into consideration. The report says that there was an opinion that it is practically difficult to determine counterparty of license negotiation with license to all approach. Also, it was pointed out that calculating royalties based on the contribution rate is considered common to the landmark decision by Japanese IP High Court in 2018. In addition, there was an opinion that the matter on whether the basis of royalty calculation should be price of parts or end product has to be separated from the matter of determination of licensee from part supplier or end product manufacturer. Following these opinions, the interim report emphasized that continuous information gathering and analysis on trend of other jurisdictions are necessary. The report also concluded that further discussion on appropriate royalty determination method is necessary with involvement of wide variety of stakeholders. This is because benefit of added value created from utilization of SEPs is enjoyed not only by manufacturing sector, but also service sector. Next slide, please. This slide shows points to be deliberated that the interim report tentatively concluded further consideration is needed, and the JPO thinks it necessary as well. I explained the first point already. This is about whether use-based license is appropriate or not. The second point is if it is reasonable to calculate royalties not based on price but on whole profit or value produced by SEPs. In this regard, there is an issue as to how royalty can be calculated suitable for subscription services that are rapidly developing. Third point has already covered. So the JPO would like to consider them neutrally with positioning the METI guide as one aspect and hearing opinions from various standing points. Next slide, please. So far, I have talked about initiatives on SAP licensing negotiations in Japan. Taking this opportunity, please allow me to explain very briefly about advisory opinion system for essentiality check, which is another pillar of the JPO's initiatives on SEPs. The JPO thinks that licensing negotiation between the parties concerned would be greatly influenced by a determination as to whether the patented invention subject to licensing negotiation is a SEP. If there is a dispute over the essentiality of the patented invention between the parties concerned, it would be difficult to resolve the dispute by themselves. Therefore, the JPO thinks that if such determination is made by the JPO from a fair, neutral perspective, it would greatly contribute to facilitating the licensing negotiation and dispute resolution between the parties concerned. Advisory opinion system, or what we call hante in Japanese, is a system originally for giving official opinion about the technical scope of a patented invention. It performs analysis just like an infringement analysis in lawsuits as to whether an object at issue falls within the technical scope of the patented invention. This is just an opinion of a patent office, and its conclusion has no legal binding force. Advisory opinion for essentiality check was introduced in April 2018. It is for the purpose of giving opinion by administrative judges on essentiality in similar manner with existing advisory opinion system. The features of this essentiality check system are almost the same as the normal ante system, that is, non-legally binding, conducted by administrative judge panel. The result will be open to the public. Patent is always rated as valid, etc. But main difference is that in the case of essentiality check, the object at issue to be checked, whether it falls within the technical scope of the patented invention, is not in a real world, but is a virtual object consisting of indispensable configurations for the standard documents. To improve convenience of the system, the JPO revised the manual of hante for essentiality check in July 2019. Although the JPO has not yet received the first request for this, the office believes that it should be helpful for resolving disputes in terms of essentiality. Next slide, please. All of the information on standard essential patents from the JPO is available on the SEP's portal site. You can download English version of various texts and documents, including the JPO guide and manual of advisory opinion system for essentiality check. Furthermore, as many disputes have continued to occur since releasing the JPO guide, the JPO carried out studies of domestic and overseas developments in SEPs. So reports of the studies are also available on this website. Please visit this site if you are interested in these initiatives. This is the end of my presentation. Thank you very much for your attention.
Thank you very much, Yoshiaki. Glad that Luke is back. Do you have any practical experience already with your essentiality test? How is it coming along?
Yeah, we are waiting for the first request from users. So we have not experienced about essentiality check yet.
Okay, and then I also wondered, just a point of clarification, when you, in the recommendations regarding the top-down approach, so you're essentially separating the contribution of the SEPs to the standard. Are you then saying it's simply the separation of the SEPs to the standard, or are you saying it's a separation of the SEPs to the standard depending on whether the standard is used in different verticals, or do you not do that?
In terms of MediGuide, it is difficult to explain the intention of this approach, but I think it is not limited to the specific situation.
That's what I also thought. I also read it that way. I just wanted to make sure. Enrico, look, what's your observations, reactions, comments comment, I don't know, thoughts, ideas, a little bit of advertisement.
Sure. Thank you, Roya, and thank you, Yoshiaki, for a really exceptionally clear and precise presentation. I'm going to say a few words about the European approach in comparison with the Japanese approach, and then I'll hand over to Enrico, who's going to make some more detailed comments about SMEs and other factors to take into account. The first thing that I'll say is that I read the ministry document when it came out, and Enrico and I wrote a blog post summarizing it during the summer for the patent blog. And one of the reasons that we wrote that blog was that we were really fascinated by the document and very impressed by it. It is a step forward in our view in terms of adding clarity and detail and precise instructions and guidance for anybody who's involved in trying to calculate royalty rates or even trying to define the value of standard essential patents when that cannot be negotiated easily between the parties. So, as far as I'm concerned, even though it is obviously centered on the Japanese market and the Japanese legal system, there's no reason why it can't be useful to arbitrators and to judges across the world. In my view, it goes far beyond the guidance that we have in Europe at the moment. We do have the European Commission communication from 2017. Enrico will talk a little bit more about it in detail. But although that Commission guidance in 2017 was useful, it was much less detailed than this particular report. And it focuses on kind of generalities, transparency, good faith, the idea of balancing intellectual property rights and competition. And as a result, we are reliant in Europe on court decisions to actually kind of give us hard guidance. Cases.
Look, this is about to change now. I think end of November, the European Commission is coming up with a hundreds of page-long documents.
Well, great.
Well, I don't know, but which is exceptionally detailed. So
well,
I think this is changing. The question will then be more of the contents of the document and the way it was prepared, I believe. But this is happening. Good.
Well, it's a positive step, but it doesn't. One of the points in the Japanese document that Yoshiaki illustrated very well was that even with the detailed guidance of the Japanese document, it's still not easy to come to a solution when parties are in, a volatile and sometimes angry dispute with one another. There's still a lot of factors that need to be weighed up. And, I do agree with the Japanese view that the contribution-based approach to value is very sensible. The question is, how do you get the parties to agree to that? I don't know, Yoshiaki, whether you want to say anything more at this point or whether I should hand over to Enrico to give some more detailed points.
I can.
Can I say something before? Look, what would be, however, interesting is if we shouldn't develop a guideline for the United Kingdom on FRAND, because with the United Kingdom leaving the European Union soon, I think it would be very important in the context of formulating a governance framework for the United Kingdom. I think it would be very helpful to have policy considerations and to think about how this could be organized, because there's a lot that could still be done to bring this element to the UK policy formulation, which has so far not figured on the agenda of British politicians in any way, or could the UK Intellectual Property Office consider taking ownership of this question? We clearly have a lot of work to do for the United Kingdom in times of setting a good governance framework around the IoT, around industry, AI, etc., where interconnected technologies will play a very important role. That I think is a very
well, so far
interesting.
the UK has kept an eye on the European approach, and obviously the way that the UK Supreme Court and the lower courts have dealt with these matters has been to follow the Huawei court guidance from the Court of Justice, and of course to consider the European Commission's communication. So in the kind of immediate term, the next 6 months to a year, the UK will probably stick with that. It's hard to imagine the UK shifting quickly, but as you've said, from 2021, the link between the UK and the EU legal system will well and truly be severed. And so the UK Patent Office within the wider UK Intellectual Property Office could decide to come up with a similar report. It'll be very interesting to see what the EU equivalent report says, whether it goes into the same level of detail, whether it exceeds it, and whether there are any points of contention between the EU report and the Japanese report. The UK may seek to carve out a unique space for itself in this area.
That's what I think, yeah. What is the unique edge for the UK? But there's a lot of thinking around this happening right now.
I mean, at the moment, the unique edge is provided by the courts, not provided at the policy level. It will come down to whether the UK government, represented by the UK IPO, believes that actually not prescribing these rules and these guidance levers in great detail, whether that is actually a beneficial thing for the courts, giving the courts a lot of freedom to impose royalty rates as they see fit, to issue injunctions as they see fit, to decide questions of global rates as they see fit. So at the moment, that is the UK approach, and if it continues to be somewhat beneficial to the UK legal system to take that approach in terms of attracting litigants, then the government will not be hugely motivated to change that.
Enrico, what do you say?
Yes, I mean, I just wanted to give, my opinion on these guidelines. First of all, thanks Yoshiaki for this very clear and complete presentation. I mean, we wrote that these guidelines certainly represent an important intervention into the ongoing debate, a clarification into the ongoing debate on SCPs, FRAND. There is no doubt that the exercise of monopoly power by SCP owners leads to the need for implementers to obtain multiple licenses, right? And this need to obtain multiple licenses is particularly evident when it comes to multi-component products that contain many parts. Game machines, construction machines, personal computers, and so on and so forth. So the risk of hold up here is very high in these industries. So these proposals, these guidelines, these general principles underlined there. So the top-down approach, the license to all approach are all welcome. The top-down approach is not new. As we know, a type of top-down approach was relied on in some cases in the US in 2013 in the reign of innovation IP Ventures. In a Japanese case, 2014, Samsung versus Apple Japan. So it's not new; it has already been used. And the license to all approach, I mean, it makes sense in my opinion. It would entail that SCP owners have to give licenses to all those companies that seek such licenses, regardless of their position within the supply chain. So manufacturers of the final product, suppliers of parts, including primary subcontractors, secondary subcontractors. So the main reason is to avoid discrimination, right? Well, there are even more radical, let's say, proposals. For example, it has been proposed years ago about the most favored licensee clause. It's a bit controversial, of course. SCP owners don't like very much, but I mean, there is a real need to eliminate any discrimination against implementers, and the most favored license clause is one. I mean, could be one of those tools. I just remind how it works. This MFL clause would require the SAP owners to promptly notify a licensee of any license granted by them to a third party for the same patent under similar circumstances, which gives rise to terms and conditions that are clearly more favorable than those granted to that licensee, right? So this would allow the licensee to require SAP owners the replacement of the terms and conditions of its license with those of the third party, right? So this clause clearly aims at making sure that no other licensee will obtain better terms and conditions. So something which could be complementary to the license to all approach. As I said, it's quite controversial. It's a controversial proposal. So another aspect that I would like to highlight is the fact that these guidelines also note that as opposed to big corporations, small and medium-sized enterprise SMEs are at a greater risk of striking licensing terms on unfavorable conditions, because of course we know that they do not have large resources not to deal with the negotiations over standard essential patents, including human resources, lawyers, relevant information necessary to conduct very long and difficult negotiations. So SMEs are at a greater risk of being hit by exorbitant license fees, or if negotiations fail, potentially devastating injunctions, right? So the attention to SMEs is not new. For example, in the communication of the European Commission in November 2017, so basically 3 years ago, well, concerns were really expressed by the Commission, right? Especially one of the burning issues there was the lack of transparency in the context of SCP licensing frameworks managed by the standard setting organizations, right? So what is important, being able to access precise and accurate information on the scale of exposure of SCPs, well, is crucial. It's crucial to SMEs, especially to SMEs, which have little experience of licensing practices, as I said, and they want to enter these markets looking for connectivity. So this is a scenario that potentially leaves SMEs in a difficult situation, right, with respect to licensing negotiations. Then there are also issues of, declarations of essentiality, which have been mentioned by Yoshiaki in the presentation. We need probably an independent party, right? As the Commission said in the communication, an independent party which checks the essentiality status. This is an old issue that remains. So in our opinion, overall, these guidelines are a positive intervention. In the debate in the field. They should assist implementers of standardized technologies and patented technologies to strike favorable licensing deals. Those, therefore, counterbalancing the monopolistic position of SCP owners. And therefore, this would benefit, in turn, final consumers via better value products capable of interoperability. So, I mean, overall, it's a positive intervention. Let's say we do believe. I think in the last 5 minutes, probably what
we have also so many questions, Enrico.
Okay.
Shall I maybe look? I haven't even looked. Like we have 8 comments or so, all from one person. Okay, let's see. Also ist das do you agree that the term Kanga e Kata means a way of thinking? The English term guide or basic concept seems misleading. Okay, why was the METI guide created by the Manufacturing Industry Bureau and not by Industrial Structure Council, which includes the JPO? Then another question is, could you please clarify which document the two speakers are now speaking about? METI guidelines, JPO guidelines, JPO interim report is not clear. The fact that SMEs and startups are targets of patent holders is a myth. Targeting SMEs and startup would mean wasting money as the expected royalty incomes would be very low. Any comments, any reactions? Then we have another chat. Okay.
Well, Yoshiaki would be the
Good morning,
person.
Mr. Kodachi. Let me read the other guys. From Vodafone, Jochen Meyer. Mr. Kodachi, this is the very best presentation on the topic I ever saw today. Thank you very much. That's quite a compliment. Thank you, Jochen. Roberto Dini from Siswell. Did you consider that sometime a SEP patent applies only to the end product as an anti-crash system for cars? Is the merit to give a SEP license to a component manufacturer and the feature regards only the car? These are all really tricky questions. Good luck answering them. I'm happy I'm just the moderator.
Okay, so I would like to ask the question about why was a METI guide created by Manufacturing Industry Bureau and not by Industrial Structure Council. So basically, as I explained, when we at the JPO intended to make an important policy decision, including law amendment, we usually consult with a patent system committee, which is under the umbrella of the Industrial Structure Council. So this is a formal process. On the other hand, METI guide was created by the Manufacturing Industry Bureau. It was from the I would say some research project. So characteristic between the study group for the METI guide and subcommittee of the patent system is a little bit different each other. So it is a little bit difficult to directly explain why, but I can say that the characteristic of both groups are different. And the METI guide is from the METI's concern that the current situation about the SCPs could hinder the development of the industries. So maybe I'm not sure this is the right answer to this question, but this is what I can explain right now.
Okay. Are the results of the Hantai project public, and how much does Hantai cost per patent? Are JPO examiners competent to decide questions of infringement essentiality? Sharaz Gilbert background is a former examiner from the EPO and is now with Via Licensing after having been an entrepreneur for years.
In terms of Hantai, the price of Hantai is 40,000 yen for one application. It is less than 400 euro. And sorry, what was the question? First point.
Does that thing work, and how much is the cost of that whole thing? And is it public, the Hantai?
Yes. So yes, the result of Hantai will be published This advisory opinion is made by the three judges, basically. Three administrative judges. And they were originally the patent examiner, and they promote to the administrative judges.
Interesting. We have a question from an colleague from Africa who raised concerns about this whole question from an African perspective, and he sent me yesterday a 3-page long assessment, and I think it's best to just give him the floor and let him ask this stuff himself. I think it contained that Japan is essentially a top technology country and a leader in the world in many ways, but what does all of this mean for a country in Africa? And I don't know, I gave you the floor if you would like to just state your questions yourself. I hope I may not be paraphrasing that the right way. Is he still here? His name is Yunumba or something like that. Yeah, Mr. Yomba Mbon, Joseph, you have the floor if you want to say something.
Bon.
We can hear you, yes?
Right?
Yes, that's a very poor connection. Is this better now? No, we lost him, I think. I don't know. Well, I don't know. Do you have, with me having paraphrased that, where do you see the chances for developing countries in that game? And where do you see opportunities for countries in Africa to even be part of that and sort of like not create further frictions in the international IT system, but to bring people in?
Is that okay?
Yes, we hear you now.
Hello.
Yeah, we hear you, Joseph. Never mind. Joseph, I think I roughly summarized what you say. Do you have any comments on that?
Please.
Do you, Enrico, Luke, Yoshiaki?
My question goes to
Go ahead.
the expert, Mr. Yoshiaki Kodashi. My question is related to Mr. Yoshiaki Kodashi.
Yeah, go ahead.
Good. I agree with you. Of course, it is most of absolute right, moreover, to make his own policy of regulating technological market and or science precisely because of his status and his very high profile in the nomenclature of industrial country development.
We can't hear you properly.
More.
Yeah, but do
In
you have
background, and therefore and technological work that user and China have waged in recent years, and which almost won the world economy. But this additional industrial, scientific, and technological lifeline,
yes,
it
so
is not
maybe
too much
yes,
in the
great.
global market, which requires more convergence of views and policies to be adopted applied for common of all. That is the question, which goes to Mr.
Joseph, your line is very bad.
Kodashi.
We hear only every second sentence, I'm afraid. I don't know, we have difficulties hearing you. Maybe Yoshiaki could comment based on my short summary, and then I fear we have to close the session. Or Enrico or Luke.
Well, I mean, it's a shame Joseph, we couldn't hear your full question, but the challenge in Africa about connectivity is going to be crucial for the continent's development. As I'm sure the other panelists are aware, and Joseph, will be living this, that Africa is moving to a mobile communication system without having had the kind of cable wired systems that we've been used to in the 20th century, let's say, in Europe and Asia and the US. So if we have problems arising from SEPs in Africa blocking technological progress, then that's also blocking developmental progress. I'm not aware of any cases involving Africa at this point. I don't know whether Yoshiaki or Enrico, you're aware of any cases. Enrico visited Zimbabwe last year, so he may know more about the legal system there. But it's certainly something that everybody has to keep an eye on, because that is how connectivity is coming to Africa. It's coming through mobile communications.
Great. Well, thank you very much for joining, for lasting so long, and for this extremely helpful overview. I'm profoundly thankful to Yoshiaki for this great presentation, for giving us insights of what's going on in Japan, and for our sharp commentators for asking critical questions. Thank you very, very much. Have a lovely afternoon. See you soon in one of our next panels. Thank you again. Have a nice afternoon still. Bye-bye.